Weighing the advantages and disadvantages of revocable living trusts in Illinois. Planning for the future involves choices that shape your legacy and impact your loved ones. In Illinois, many residents must decide whether a simple will or a revocable living trust better serves their needs. A revocable living trust is a legal arrangement that holds your property under your control but allows smoother management and distribution when you are no longer able to do so. Working with a knowledgeable lawyer can help you avoid pitfalls and tailor your plan to your unique situation. When you create a revocable living trust, you fill three key roles. As the grantor, you set the terms and transfer assets into the trust. You usually act as the trustee, keeping full control of your property while you are alive, and you also name a successor trustee to step in if you become incapacitated or after your death. During your lifetime you are usually the beneficiary, and after your passing the beneficiaries you name, such as a spouse or children, receive the trust's assets according to your instructions. Because the trust is revocable, you can amend its terms, change beneficiaries, add or remove assets, or dissolve it entirely. Proper funding is critical. You must transfer real estate, bank and brokerage accounts, and business interests into the trust's name so those assets avoid probate and remain under the trust's control. A central benefit of a revocable living trust is avoiding probate. Illinois requires probate for estates that include real estate or assets worth more than $150,000. Probate proceedings often last 6 to 12 months or longer and involve court filing fees, publication costs, surety bond premiums, and attorney's fees. A properly funded trust allows your successor trustee to manage and distribute assets privately and efficiently, often within weeks. Privacy is another advantage. While a will becomes a public record when filed with the court, a trust document remains private and confidential, shielding your family's financial affairs from public view. If you become incapacitated, a revocable living trust ensures your successor trustee can manage your finances immediately, pay bills, and protect your property without court involvement. A trust also provides detailed control over how and when beneficiaries receive their inheritance. You can hold a child's inheritance until they reach an appropriate age, provide for loved ones with special needs without jeopardizing benefits, set conditions based on milestones like completing college or maintaining sobriety, and include spendthrift provisions to protect assets from creditors or divorce. By unifying real estate owned in multiple states under the trust's name, you eliminate the need for separate probate proceedings in each state. Despite these benefits, a revocable living trust has limitations. Creating one requires more time and expense than drafting a simple will, including the administrative work of transferring assets into the trust. Ongoing maintenance is essential. Whenever you acquire new property or experience major life changes like marriage, divorce, or the birth of a child, you must update the trust and retitle assets accordingly. A revocable trust does not reduce estate or income taxes and does not protect your assets from creditors or lawsuits. Because you retain full control, the IRS treats the trust's assets as your own, and creditors can reach them as well. Deciding whether a revocable living trust is right for you depends on your assets and family situation. A trust is strongly recommended if you own real estate in Illinois, hold property in more than one state, have a blended family, value privacy, want protection in case of incapacity, or need to manage inheritances for minors or beneficiaries requiring oversight. A simpler plan may suffice if your assets total less than $150,000 and you own no real estate, or if your family structure is very simple and major assets already have designated beneficiaries. Weighing the advantages and disadvantages helps you make an informed decision that aligns with your goals and protects your family. To determine the best approach for your estate plan, consider consulting a Chicago attorney experienced in trusts and estates. A skilled lawyer can explain how a trust operates, help with funding, and ensure your documents reflect your wishes. For those who wish to avoid probate, maintain privacy, or provide long-term oversight for beneficiaries, A revocable living trust can offer the flexibility and control needed. Illinois estate law firm can guide you through your options, assess whether a trust suits your circumstances, and prepare the necessary documents. Call Illinois Estate Law at 312-373-0731 or visit their office at 4422 North Ravenswood Avenue Suite 212, Chicago, Illinois, 60640 to learn more about creating a personalized estate plan.